Three. Rah. Three. Rah.
Nothing to add. Been out since September the 20th.
All right, go ahead, Mr. Dobbs.
Thank you, Judge Manning. Mr. Robinson has been out for about 6 months on a ankle monitor. We are here asking for the removal of that ankle monitor. This is, of course, a ankle monitor that is being paid for with county funds. And I don't see any indication that Mr. Robinson is a flight risk or a danger to society. These are two Title 40 misdemeanors that he's had to have his liberty restrained by this ankle monitor for 6 months for. Which we just don't feel is reasonable given the amount of time that has passed. My office did consent to a UJR for Mr. Robinson to include the ankle monitor to be paid for by the county. I was not a part of those negotiations, and I did not sign the document, but I'd like to posit to the court that it's not as if just 1 month has passed and I'm asking for this to be removed. This has been 6 months that he's had to keep up with this. Further, Your Honor, and this is mainly a issue for another day, but I do just want to state the warrant doesn't actually establish that this should be felony level. It's based, whether you're felony or misdemeanor, is based on convictions, and that is not established in this affidavit. I've also looked at Mr. Robinson's criminal history, and I don't see, I didn't see the requisite amount of convictions there, unless I'm missing something to make this a felony. I'm not asking today for the case to be moved or anything like that. I'm simply asking for the removal of the ankle monitor. But I just want to state for the court that I believe this is a case that under most circumstances, given where it was charged, given that it's Title 40 misdemeanors, would have probably gone to the city of Atlanta court and likely, wouldn't have even resulted in an arrest, since I'm positing that it shouldn't even be felony level. So in short, Judge, I don't feel that Mr. Robinson is a flight risk or a danger to society. I see no reason why public funds should continue to go towards his ankle monitor. I see no reason why his liberty should continue to be restrained on these two very minor charges. I'm asking for the removal of the ankle monitor condition, and that all other conditions remain the same. Thank you.
Go ahead, Mr. Malcolm.
Thank you. I sent Mr. Dobbs a chat before court started this evening. I don't know if he's had an opportunity to see it, but the bond in this case was negotiated and agreed to by Mr. Dobbs's office and by the DA's office. And so any question as to whether the appropriate charge is a felony or not would have been resolved certainly by them when they discussed it. Mr. Dobbs said that he's just charged with 2 misdemeanors, but that's not, in fact, the case. He is charged with a felony. And Mr. Dobbs also said he's not a danger to society or to the community. But the fact that it's his 4th or subsequent driving on suspended license charge, by definition, indicates some danger to the community. And since this was a consent bond that was agreed to by Mr. Robinson through the public defender's office as recently as September, I suggested to Mr. Dobbs that he re-request this in several months, 3 to 4 months. And that's what I'm asking Your Honor to do, is to deny the motion. And perhaps Mr. Dobbs may want to refile it in 3 or 4 months. But at this point, since it was a consent bond by the defendant and Mr. Dobbs's office, it's too soon to remove the ankle monitor.
May I
so I'm reading the warrant, and it says his license has been suspended or revoked multiple times for failures to appear. 3/6/2023, 1/16/2023, 11/3/2022, 4/18/2019, 11/12/2018, 5/6/2019, 2/13/2018, 11/7/2017, 12/25/17, 11/7/17, 4/4/18, 12/23, 2/15, 12/19/12, 9/19/2011, 6/2/2010, 10/23/2008, 11/23/2006, 2/10/2004, 11/28/2003, and 10/1/2003. Go ahead.
May I respond to Mr. Malkin, not what you just said.
Sure.
I'm sorry, Eddie, not to what you just said. Well, I guess partially to what you just said. I was positing, I'm not taking umbrage with anything you stated there, Judge. I was just positing that this shouldn't be felony level because that's based on convictions. There's nothing about convictions here. I have looked at his criminal history. He doesn't have the requisite amount of convictions, at least not in Georgia. I'm not asking Your Honor to do that. I'm simply asking for the removal of the ankle monitor. I don't know what difference 3 more months on an ankle monitor is going to make. I highly doubt the case will be moved forward by then. Anyways, to me, that's just 3 months of my client's liberty being further restrained and more money going towards and more public funds going to a ankle monitor. So that is why I'm asking for the removal of the ankle monitor. If I did state that the suspended license was a misdemeanor, I meant to state that I believe it should have been charged as a misdemeanor. Thank you.
All right, Mr. Robinson, can you take yourself off mute and raise your right hand? Do you swear affirm testimony you're about to give is the truth, whole truth, nothing but the truth? Take yourself off mute. Okay, hit that little microphone.
Okay, I'm off mute now. I got it.
All right, state and spell your name for the court reporter.
Lavelle, Levell, Robinson, Robinson.
Have you been working?
Off and on, man. On the day that I got arrested, my truck got stolen, so it's been kind of difficult getting back and forth to work.
So how you been getting back and forth to work?
Either martyr or catch a ride or do a little odd job with different people. It's not a permanent regular job, but I do work regularly when I'm able to get there in a timely manner,
But you ain't been driving to work.
I don't have a vehicle at all. I don't even have a bicycle.
What if you did?
Ma'am?
What if you did have a vehicle?
I'm going to get my license taken care of, Your Honor. I mean, I'm working on it right now. It's just a couple of more things that I got to do as far as get this case off and just get some fines paid and they'll be reinstated.
That's a whole bunch
nothing big.
That's a whole bunch of fines, though.
Well, no, I actually have them trundled down to 3, and I would get some assistance because of the fact that I received some kind of disability. I already done looked into it, so I will receive assistance with that, and I'm actually anxious to get them back. I'm really ready to get them back.
Your Honor, his current bond condition prevents him from driving at all.
Yeah. So right now. Yeah, because it says shall not drive. So right now we'll remove it, but you can't drive unless you can show the state that you have a valid driver's license or your bond's modified. Okay.
Yes, ma'am. Because I don't have a vehicle anyway. I don't have anything to drive at all.
Get yourself a bicycle.
Yes, ma'am. We're gonna lift this ankle monitor.
All right, Mr. Dobbs, just send it to me, but it'll stay in place at no driving unless his bond is modified or he shows the state he has valid license.
Thank you, Judge. Mr. Robinson, I will send you a copy of that order from the judge to take to the ankle monitoring company. Thank you very much, Judge Manning. May I please be excused?
Yes,
so,
sir.
Mr. Dobbs, that mean it's coming off?
My understanding is that Judge Manning is agreeing to remove the ankle monitor,
Yes,
but maintaining the condition that you cannot drive at this time. Okay?
Okay, understood. That's understood. No problem. Okay, understood. So you're going to send that to me via email?
Yes, tomorrow.
Okay, thank you. Thank you, Judge.
All right. Thank you, Mr. Robinson. Thank you, Mr. Dobbs.
Bye-bye.
May I please be excused?
Yes, sir. Have a good evening.
Thank you,
All right.
Judge. Have a good evening.
Miss Murray, Dominique Isal, 23 CP 222592. It's number 1 on the bond modification calendar, Bostic. Right now, he's out on a $30,000 bond, unlawful for a person employed by, associated with a criminal street gang to conduct or participate in criminal street gang activity. Unlawful for a person employed by, associated with criminal street gang to participate in criminal street gang activity, and unlawful to commit the offense with the intent to obtain, earn membership, maintain, or increase status in a criminal street gang.
Nothing to add. Been out since December the 2nd of 2023.
All right, go ahead, Miss Murray.
Your Honor, we are here today to ask that Mr. Isal's ankle monitor be removed. Mr. Isal has been out on bond since December 2nd, 2023. He was ordered to wear an ankle monitor that is self-paid, so he is currently paying the $350 a month that it costs to keep that ankle monitor on. As far as we know, Mr. Isal has been in complete compliance with the conditions of this court's bond order. And has had no violations in regard to the ankle monitoring company. We actually, on January 4th, 2024, had a bond compliance hearing in front of Judge Drake. At that time, somebody from the ankle monitoring company was on and said that there were absolutely no violations, not even so much as a failure to charge his ankle monitor. So he has been completely in compliance with those conditions. However, the ankle monitor is a financial burden on Mr. Isal. He is having a hard time providing for and caring for his family. His girlfriend is now probably about 7 months pregnant. At this stage in her pregnancy, she is experiencing some complications that require Mr. Isal's support and assistance. However, due to his curfew and this ankle monitor, it's difficult for him to be present. Once the baby is born, he would like to be able to be present and active whenever needed for his child. In addition, Mr. Isal has struggled to find full-time employment due to having the ankle monitor and due to his curfew. One of the conditions of his bond is that he enroll in a GED program. He did do that. He is currently working on getting his GED, but between getting his GED and then the hours of his curfew, it keeps him, very busy. It's hard to find full-time employment. And, also walking around with an ankle monitor isn't necessarily a good look for employers. So he has been doing yard work and car maintenance for his uncle to earn as much money as he can. However, this is not as much money as he would like to be earning to be able to support his child. So we would ask that the court remove the ankle monitor and either extend the curfew to later hours or remove the curfew. If the court is not inclined to remove the ankle monitor, we would at least ask that the curfew be adjusted to give him more hours that he can be, with his child once that child is born, or just, working and supporting his family.
So where is he at right now? Looks like he's in a car.
Yes, Your Honor. I believe so. He's probably at work. But the curfew is from, I believe it's 7 or 8 p.m. to
7 p.m. to 7
early in the morning.
p.m. to 7 p.m.
Yeah.
Mr. Isal, take yourself off mute.
My curfew.
Take yourself off.
Stop.
Stop. Raise your right hand. Do you swear affirm testimony you're about to give is the truth, whole truth, nothing but the truth?
Sure.
Where are you at right now?
I am in my car in front of my auntie's house.
What are you doing at your auntie's house?
I came to my auntie's house. We're about to have a baby shower in 2 more days for my daughter.
Okay. So what are you doing there right now?
I came to my auntie's house because we're supposed to be ordering the cake because we got to put the ultrasound picture on the cake. She's supposed to be ordering the cake and getting the stuff.
For the record, Your Honor, his
I just saw the modification. I saw the modification. Go ahead, Mr. Powers.
Judge, I was the ADA at that hearing back in January where his modification took effect. This is a situation where Mr. Isal does look like he has been doing what he needs to do. We would just leave it in the court's discretion.
So he is curfew from 11 p.m. to 5 a.m. Now, when are GED classes? Because they're not 7 days a week. I mean, people do them online. They're only for, a couple hours. They're not all day, every day.
His GED classes are.
I do take my GED classes every day. I do them every night. Every night I have to do GED classes. But as I've been trying to go get employed and I've been going to warehouses and stuff, they want overnight workers. So it's like I have to go get a daytime job. Even like Wendy's and stuff, I don't apply that. Wendy's, McDonald's, stuff like that. Like that, it's just the ankle monitor is a bad look. They don't want nobody to like, and they know that I can only work at a certain time.
Ms. Murray, do you have any proof that he's gotten a job offer for at nighttime? Mr. Powers, if he had an offer for an overnight job at a warehouse, as long as he was there, would you have a problem with him doing that?
Not at all, Judge. Yeah, we would like Mr. Isal to be working and contributing to society. So if that's something that's available to him, that's fine with us.
So, Ms. Murray, we can leave it on there. You can change it to that the county pays for it. But what you can do, which it sounds different, Mr. Isal, is you can make it a 24-hour curfew. But what that does, if you're not at work, whatever your work hours are, at court, seeing your lawyer or with your child, then you got to be at home.
Well, Your Honor, we wouldn't request a 24-hour curfew. That would further restrict Mr. Isal's movement. And, he's presented no issues that
That
would show
allows
that
him
that's
to do,
necessary.
that allows him to do what he wants to do. If he wants to be with his child and work and see his lawyer, and he needs to, do that.
But that's not. But how as of right now, only thing I can do is work with my uncle and cut grass and wash cars.
But you can go get a job. If you get a job and you can prove that you're working at X warehouse from midnight till 7 a.m. and you can show Miss Murray, then you can go to work.
Your Honor, we would just request that instead if the court maintain the 11 p.m. to 5 a.m. curfew and make the exception that if he is at work, then that would be the exception to the curfew.
Go ahead, Mr. Isal. You were saying something. If you got that, it'll allow you to work whenever you need to.
No, I don't. It's not about that. It's about the paying. Every dollar that I make, I have to pay for this. And
We already said I'm going to let the county pay for it.
Yeah, well, I don't have a problem there. I really just, it was the paying it. They had me paying for it, and they also just told, at first it was 7 to 7. So every interview I went to, they were just like, oh, you can only work this time to this time. But then they changed it to 11 p.m. to 5 a.m. and that's been all right. I ain't had no problem.
So now you can find a job. All right. So we'll just change it so the county can pay for it. We'll leave the ankle monitor on there.
Okay.
So shoot me that, Miss Murray.
You'd like me to draft the order, Your Honor?
Yeah, you just said that the county will pay for it starting immediately.
Okay.
All right. Thank you, Mr. Isal. Good luck. Congratulations.